Hey everybody, I'm going to explain to you all the case law behind abortion. I'm going to put this into plain English because I see a lot of people posting about the most recent decision that's been made by SCOTUS. And a lot of people are very confused about exactly what it means, and they're misinterpreting the law. Therefore, I'm going to turn this law into complete English. So whether you are a law student, whether you're an attorney, whether you're someone in society who doesn't know anything about the law at all, you can watch this presentation and hear me explain it, and you can understand it as if, again, it's plain English. So we'll walk through this one step at a time. I made an outline, a very clear outline. We're going to walk through Roe v. Wade, which is the trimester standard in that case. Then we'll get into Planned Parenthood v. Casey, which is the undue burden test. The undue burden test is the law of the land before the case that happened yesterday. Then we'll get into Dobbs that happened yesterday. We'll get into the meaning of abortion as of today due to the Dobbs case. We'll talk about federalism and how it applies, and then we'll conclude it all. So let's get into it. This is the Burger Court. This is the 9 Supreme Court justices that decide Roe v. Wade in 1973. Just so you can get a visual, these are the 9 justices. Roe v. Wade. We're going to go through the facts. The facts are very clear cut. Okay. So Jan Roe, a pregnant woman, lived in Texas, and she filed a lawsuit against a district attorney of her county, District Attorney Wade, for Texas criminal abortion statutes. The law of Texas at that time permitted abortions only if a medical doctor found that a woman's life is at risk. That was the only exception. If she wanted abortion for any other reason, and she still got the abortion, criminal penalties will apply. So she thought it was unconstitutional. Therefore, she alleged that she could not get an abortion because her life was not at risk in this case. She just wanted an abortion because she was pregnant. The District Court of Texas found that the right to choose is protected by the 9th and 14th Amendment. In Texas law, is unconstitutional because it is vague and overbroad. In this case, appealed to the Supreme Court of the United States of America. The Trimester One analysis is pretty straightforward. Okay, Trimester One of the state of pregnancy is that the state, the government, may not ban abortion, and it has no compelling governmental interest before viability of the fetus. Therefore, the court is saying here that, look, the fetus is not viable because we're at trimester 1. Therefore, the woman can do whatever she wants to when it comes down to getting an abortion, keeping the kid, whatever the case may be. It is in her discretion about what she wants to do with the fetus. The rationale, the reason behind this, was that the court said that the morality rate for mothers having abortions is much lower than full-term pregnancies. So basically, if the mother got an abortion at the first trimester, the likelihood of her having her health at risk or dying is substantially lower at the first trimester than the full-term timeline of her having an abortion. Therefore, the state has no valid interest in protecting the mother's health during this period of time. Trimester 2 is focused on the state having the ability to regulate, but only regulating to protect the mother's health, not the fetus's life. So the state can pass a law in regards to abortion if it's for the mother's health alone. So the laws passed must be reasonably related to the mother's life. An example of this, as I put here, is that putting the mother in a hospital rather than a clinic is an example of protecting the mother's life and health, because the mother getting a safe abortion is going to be better protected in the hospital rather than a small clinic. That's what the states could do in this situation at trimester 2. Then we finally get into trimester 3. Trimester 3 is that the fetus is considered viable. So basically, the state has a commitment of governmental interest in this case because the fetus is viable in trimester 3, they can pass laws in regards to abortion. However, the abortion must be permitted where it is necessary to preserve the health and the life of the mother. alone. The fetus is not considered a person under the 14th Amendment in this case. So if they wanted to, if the state, wanted to pass a law to restrict the mother's right to an abortion, they can't, but it has to be related to her health and her life only, and no other reason. The meaning of Roe overall, the overall meaning of Roe is that abortion is declared to be a fundamental right under the Constitution via the 14th Amendment. Okay, this fundamental right can be outweighed only if the two aspects here are satisfied, that the state has a compelling governmental interest in barring abortion completely, basically protecting the mother's life and society at hand. And the state law is narrowly tailored to achieve that interest, which means that this is the only way for this interest to be satisfied is by passing a law that bars abortion, that there's no other reasonable alternative. So if there's a reasonable alternative to the state's law, it will not be a compelling governmental interest, and that law cannot bar abortion. So that was the standard in Roe v. Wade. So let's get into the Rehnquist Court of 1992. Okay, this is the 9 justices, as you can see. You can see Scalia, Justice Thomas, Justice O'Connor, Rehnquist, Soter, etc. They are the 9 justices that decided Planned Parenthood v. Casey. So let's dive into the facts of Planned Parenthood v. Casey. So Pennsylvania had a statute which placed restrictions on abortion. And the two statutes that were really focused on in the case was that the first one was that a requirement was placed on a woman where she had to wait 24 hours after receiving information from her doctor. So once the 24-hour period is over with, after she talked to her doctor and got certain information from the doctor, she can get an abortion. And the second law that was at issue is that there was a requirement that a married woman had to notify her husband of her intent to get an abortion. The overall analysis of Planned Parenthood v. Casey is that Roe was basically reaffirmed. That was still the law of the land. However, the trimester approach that we just talked about, 1 through 3, is rejected because it undervalues the state's interest for the other 2 trimesters, Trimester 2 and Trimester 3. So because of the trimester approach, it basically undervalues what the state can and can't do in protecting the mother's life and her health. Therefore, they adopted an undue burden test. And the undue burden test is this, and I'm going to quote this because this is straight from the case law itself. State law will constitute undue burden if the law itself has the purpose or the effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. And like we talked about before, it's not considered viable until the 3rd trimester. So the first 2 trimesters, it's not viable. So that's a situation where the state law can pass whatever law they want in regards to abortion, but again, it cannot be a substantial obstacle to the woman actually getting the abortion during those first 2 trimesters. That's what that basically means. So a good example of this, let's just say Texas. They passed a law recently, before Dobbs, about women not being able to get an abortion past the 6-week mark, correct? So that would be considered on being an undue burden, basically a substantial obstacle from a woman getting an abortion, because most women do not know that they're pregnant until, I believe, the 8th week. Therefore, that would be considered a violation of the undue burden test, which is why that law was the hot topic for such a long time, because again, it violated this test, because this test is the law of the land, at least before yesterday. So to be more precise about the laws that were passed in Pennsylvania, is that the court held that Pennsylvania's law placed an undue burden on the woman's decision to get the abortion because of the following reasons. That spousal notice, basically notifying your husband, right, that requirement was a violation of the Constitution because it enables the husband to wield an unconstitutional veto on her choice. Basically, a husband will have an interest into the kid as well, because he could possibly coerce her to make a different decision instead of the decision being in her discretion alone. And the court also stated this, which I put in parentheses, is that the husband has an interest due to being the father. However, due to abortion being a fundamental right under the Constitution, the wife's interest will override the husband's interest in having the child. That's why it was an undue burden, because again, it is in her discretion alone. So even if the husband still wants the kid, even though he's technically the father of that kid, her right will override his. Secondly, the 24-hour waiting period in regards to the mother getting information from her doctor was completely constitutional. That was fine because it's a brief waiting period. It's not a substantial obstacle in her path to get an abortion because all she had to do was wait 24 hours. So the certain information that she had to receive from the doctor, I put in parentheses here, is that the medical doctor must give the woman information regarding the procedure of the abortion, the health risks to abortion, child support from the father that she could receive if she decides to have the kid, and the woman must sign a waiver in writing stating that she actually got this information from her doctor. And then after the 24-hour period, she can come back and get the abortion if she so desires. The dissent in Casey is critical to today, which is why I put it here. So the dissent in Casey at the time was that Scalia, Thomas, White, and Justice Rehnquist all dissented. They said that a woman's right to an abortion is not protected by the Constitution because the Constitution is basically silent on abortion. There's nothing in the Constitution itself that gives a woman the liberty to abort her kid. And the history and tradition of our country have permitted abortion to be legally prescribed. And they're referring to, the reason I say it's legally prescribed, because they're talking about the fact that, hey, you can technically get an abortion as long as your life is at risk. But you can't get an abortion outside of that exception. So technically speaking, abortion was widely available in this country only for that exception. That's why it states here that it is rooted in our history and tradition. And it is permitted legally because, again, abortion was technically around at the time before Roe, but the exception was the only way to get it. Therefore, the PA law should be upheld based on the rational basis test. That's what the dissent said. And we'll talk about the rational basis test in a second. The overall meaning of Casey is this, and this is what's controlling as of before yesterday, is that abortion is still considered a fundamental right under the law. Therefore, it is a constitutional right for a woman to get an abortion. Under the undue burden test, that is basically the standard for all abortion restrictions until the fetus is viable. So when the fetus is viable, like we talked about, that is when the state and the government can put their hammer down and really pass a lot of laws against abortion. So let's finally dive into what's happening today. We look at the Roberts Court as of this year. You see Justice Thomas, Alito, Sotomayor, the list goes on and on. Those 9 justices are the 9 individuals who were the justices in this Dobbs case that was talked about yesterday and more likely today. So the facts of Dobbs v. Jackson Women's Health Organization are basically these four sentences here. Is that in 2018, and yeah, it's been going on for a while, Mississippi passed a law which prohibits all abortions, with a few exceptions, one is like being at risk, after 15 weeks. So basically, this is not a situation where they're passing a law that would have a compelling governmental interest during the 3rd trimester, like we talked about before. This is during, this is almost in the 2nd trimester era. So Jackson Women's Health Organization, the only licensed abortion facility in the entire state of Mississippi, and one of his doctors, they filed a lawsuit in federal district court challenging the law, and they had standing to sue. Therefore, they found that the state had not provided evidence that a fetus would be viable at 15 weeks. And Supreme Court precedent prohibits states from banning abortions prior to viability, like we talked about. So once it's viable, once the fetus is viable, that is when the state can pass laws against abortion. And again, as we talked about before, is not considered viable until the third trimester. The U.S. Court of Appeals basically affirmed this, and it basically got appealed to the Supreme Court of the United States. And note that the undue burden test per Casey is the controlling law of the land. The overall analysis here, it's going to be very brief, is that the rational basis test controls the standard of abortion as of today. As of today, that is the test that controls. And you're probably thinking to yourself, what the heck does rational basis mean? The rational basis test basically means that the statute, the law that the state will try to pass, whether you're in Missouri, Minnesota, whatever state that passes a law, it'll be upheld. The statute against abortion will be upheld as long as it is conceivable that that law bears a rational relationship between a legitimate governmental objective. In this case, basically the viable fetus, because that's the claim here, that the fetus is actually viable. Therefore, they're passing a law to protect that fetus, which would be a legitimate governmental interest in saving the fetus's life from the abortion. That's why it was able to survive the rational basis test. And also, another thing that Justice Thomas noted is that this right to an abortion is not a fundamental right because it's silent in the Constitution. This is how we talked about with the dissent in Casey. Those are the exact same reasons about why they made the decision they did yesterday. It's similar, not the exact same, because again, these are different facts, right? Casey and Dobbs, different facts. Nevertheless, though, the reasoning is very, very similar. So the overall meaning of Dobbs as of today in 2022 is federalism. Probably thinking to yourself, what the heck is federalism? Federalism is basically allowing each and every single state to make its own decision on what can and cannot be legalized in their state. An example of this is cannabis. We know cannabis is legal in Nevada, it's legal in California, but in states like Minnesota, like Texas, like Idaho, it's illegal. Therefore, it is up to the states to make this decision. And that is what was in control before Roe v. Casey passed. It was up to the discretion of the states to make the decision on whether or not abortion should be legal, permissible in certain exceptions, or outright outlawed. So that's what's going to happen as of today. Therefore, if you are in a state like California or Minnesota or even New York, you will be able to have an abortion without any issues at all because it's up to the states, like I said. However, if you're in a hardcore red state, let's say like Idaho, Utah, Texas, maybe Florida, it'll be up to the states, like I just said, right? And they will be it's going to be permissible and lawful to make abortion illegal. That's how they're able to make marijuana illegal. So that's just an example of what's happening after today. That's the meaning of Dobbs, is that it's up to the states. Probably thinking to yourself, is abortion gone forever? Is it really gone forever? And the answer is no, it's not. It's not. Because Casey's ruling, the undue burden test, even Roe v. Wade, can be codified into law. It can be amended via the legislative branch into federal law. But the Senate would need 60 votes or more to pass that law. As you know, there are 2 senators in every single state. We have 50 states. That makes 100 senators. Therefore, they would need 60 or more senators to vote on codifying Roe into law to basically bring back that fundamental right, so all the states won't be able to ban it anymore. Or the flip side to this is that if you're anti-abortion, if you're pro-life, whatever the case may be, it can be codified too. That can ban and outlaw all abortions in the country. So again, you need 60 or more votes to outlaw abortion, to codify it into law. So if that happens, every single state will now be able to have an abortion. They'll not be able to permit an abortion for certain exceptions, like the mother's life being at risk. The overall conclusion is that I want you to read the cases, and I want you to rely on expert opinions, not a layperson's viewpoint. I literally read all the commentary online, especially Facebook, and I'm just being transparent with you. Like 99.9% of them don't know what the fuck they're talking about. They really don't know. They don't know the law. Let's be honest. Constitutional law, the law in general is very complicated. You know, I finished law school. It took me years to be able to understand this, and it's very, very hard and complicated. It can be easily misinterpreted. An example of this is that when I see people talking about religion being applicable to this current decision, that's how I know you don't know shit. You're automatically, I don't consider your opinion viable, really. Because if you took your time to read the law, to read the case, it's over 200 pages. I can see why you're lazy and you don't want to read it. I can see why people won't want to rely on lawyers and legal analysts who appear on the news. I say rely on their opinions. Don't rely on your friend's opinion who didn't even go to law school or read the cases at all. And you should think for yourself. Have your own personal opinion, whether you're pro-life, whether you're pro-choice. I'm not here to give my opinion. I'm just trying to interpret the law and tell you what the cases say and how they apply as of today to clear up some confusion. And if you're that interested in being pro-life or pro-choice, vote. If you want to codify Roe, if you want to codify abortion being outlawed in all 50 states, go ahead and vote. I'm sure your senator, assuming they're pro-life or pro-choice, will do what you want them to do. That's why you should vote. And lastly, if you want to truly change the country, whether it's this topic or whatever topic you may be interested in, instead of talking about it and posting on Facebook, you should act on it. Try to be involved. The DNC, the RNC, even other political branches have a lot of ways for you to give back to society instead of typing with your thumbs on your cell phone. And as I said, this is for legal education purposes only. This is not legal advice. So I really hope you learn from this. Again, I'm not here to give my overall opinion of abortion. I'm not here to lecture anybody, but just please, as someone who's about to be a lawyer soon, don't listen to a layperson's opinion. Do your due diligence, read the cases, and if the news, whether it's Fox News, CNN, whatever you may watch, if they bring a lawyer on, a legal analyst on, that's the person who you should listen to. Don't listen to any of those newscasters, and don't listen to your friends and peers, because again, they don't know shit about the law. They just don't. Okay. Thank you so much. And comment below if you have any questions. I can clear up any confusion. Maybe I explained it well. Maybe I didn't. I believe I did. But if I did not, comment below and I'll answer all of your questions. Thank you very much and have a good day.